Okay, this is a short video, and it's to explain a distinction that we might want to draw when we're dealing with a case where, for instance, the owner of property is complaining about a trespass by protesters, and protesters are claiming that that they have a free expression right that requires them to go onto the land in order to protest, that without being able to go onto the land that allegedly they'd be trespassing on, they won't have a suitable opportunity to express themselves. And in dealing with that particular balance between the right of the property owner to exclude from his or her property and the right of the protesters to go onto the property in order to protest, I drew a distinction between the court ruling that it wasn't to be a trespass, it wasn't a trespass to go onto the land to protest, and the court instead dealing with the matter at a remedial level, perhaps by saying that although it was a trespass, an injunction would not be available or would not be immediately available, instead only the prospect of an award of damages. And the question that was raised with me was, well, why draw that distinction? Why distinguish between changing the line between tortious, not tortious, and changing the remedy? Well, the answer I'd give to that is an answer that looks at two dimensions of the problem. The one is that we might think, well, the balance is affected by which level we deal with the issue at, in the sense that if we say not a trespass, not a wrong, then that reflects a particular balance between the right of the property owner to exclude and the right of the protester to go onto the property. The protester now has freedom to go onto the property. It's not a wrong. By contrast, if we say it is a wrong, but we won't immediately grant an injunction, instead perhaps just award damages for the wrong, that we might say, well, maybe that reflects a slightly different balance. That in this situation it is a wrong. There is some possibility of a remedy. It's just not such an intrusive remedy, just the payment of damages rather than an immediate injunction. And of course, the payment of damages rather than an immediate injunction may give the protesters a better opportunity to express what they want to express, albeit there will be a consequence. So it would be a bit like in the context of defamation law, where we draw a distinction between granting an injunction, a form of prior restraint, and the making of an award of damages afterwards, and think that the award of damages, in particular if it's kept at a moderate level, would respect free expression more than a form of prior restraint, such as an injunction underpinned by the threat of being sent to prison might do. A second reason for thinking about this distinction, apart from it from a balance perspective, is of course if we're thinking about indirect effect of fundamental rights on the common law, that from the perspective of a judge, whether a judge has constitutional power to change the boundary between trespass and not being a trespass might be a different question from whether a judge has constitutional power to alter the rules on when one remedy will be available rather than another. Indeed, it might be thought to be straightforward that judges already have a discretion as to what remedy they would award, or a discretion as to whether they would award an injunction in the circumstances. And so there's less need for a radical step by the judiciary in order to use the not an injunction but damages instead approach, rather than altering what counts as a trespass approach. Now, of course, in the seminar we also raised a further problem, which is, well, if we use the approach of saying no injunction, just the prospect of damages, well, what about self-help? And the fact that normally somebody who is the victim of a wrong is entitled to use reasonable force to look after their rights, reasonable force to exclude the trespassers. I guess that there, in a sense, we have a different forum or different situation where we could ask the same two questions. Might we modify the right of self-help, which presumably is some sort of privilege to use force on another person, and so we could modify. We could say, well, it is a wrong, but you can't use self-help here, and we could look at that both from the perspective of the balance involved in making the law such that you couldn't use self-help, but also in terms of whether that would be within the legitimate power of a judge to change the law in that way. So I think that was the reason for drawing the distinction.